Good morning. Before I proceed, can everyone hear me all right? Is this mic working? All right, excellent. My name is Darren Dick. It's my pleasure this morning to moderate our panel on vulnerability disclosures. We're going to spend about the next 50 minutes talking about that. Just for your purposes, I plan to ask a few questions to the panelists, but reserve plenty of time for questions at the end, so please ask those questions if you have them. Before we get started, let me just take a moment to introduce our panelists briefly. Leonard Bailey is Special Counsel for National Security in the Department of Justice's Computer Crime and Intellectual Property Section and a senior member of the section's Cybersecurity Unit. To his left is Harley Geiger, who is Rapid7's Director of Public Policy, and he leads Rapid7's cybersecurity policy and government affairs activities. Next to Harley is Heather West, who works on security, data governance, net neutrality, and privacy in the digital age at Mozilla, the maker of Firefox browser. And next to Heather is Sam Curry, who is the Chief Product and Security Officer of CyberReason. And so with that, let me just go ahead and dive right into to our topic. Leonard, in July, the department issued its framework for vulnerability disclosure programs. Would you take just a couple of minutes to tell us what drove the development of that framework and what are some of the aims that the department was trying to meet?
Sure, thank you. And thank you to the Alliance and the Coalition for inviting me to come out and speak to you. I've answered this question a lot because there's some confusion as to why the Department of Justice would be in the area, in the lane of vulnerability disclosure policies. And this goes back to December of 2014 when we started our cybersecurity unit. Now, the Computer Crime and Intellectual Property Section is the component of the department that's responsible for prosecuting computer crime cases along with the U.S. Attorney's offices. It also is the department's experts on electronic evidence issues, on electronic surveillance of computers under criminal authorities. The creation of the cybersecurity unit, though, was intended to take those areas, what we've learned in those areas, expertise and knowledge, and apply it to perhaps preventing computer crime where we could. And so we've taken on this mission of trying to identify places in the law where we might be able to provide guidance that will encourage better cybersecurity practices. We had worked with the DoD on its vulnerability disclosure policy, and after that, we asked the question, is there more to be done here? And one thing that you kind of couldn't miss was that the market was starting to value these programs. And when I say starting, we're probably late to the game because as the government, we often are. But once you see, Twitter, eBay, Facebook to the tune of $5 million for bug bounties over 5 years, buying into these programs, you have a notion that there is merit that industry is seeing in them. So we thought that there was a reason to issue guidance that was intended to deal specifically with the Computer Fraud and Abuse Act, which is a federal computer hacking statute, and its intersection with vulnerability disclosure policies. And so our policy our framework really applies to activities that involve online systems rather than other types of close access research. But the idea was to make sure that we could lay out a framework for parties who were interested in creating a policy or program that provided them guidance without dictating any particular form for how they may construct these programs to provide clarity, ideally unambiguous clarity, on authorized conduct. And the reason why that's important is because under the Computer Fraud and Abuse Act, you're prohibited from accessing a computer without authorization or an excessive authorization. So with the framework, we attempt to walk through the decisions that you'd have to make in planning a program, in drafting your procedures, and in implementing the program ultimately in a way intended to reduce the likelihood that there will be disagreements that may blossom into litigation under the CFAA.
Thanks for outlining that. Harley, as Leonard was outlining, it was the framework helps delineate between authorized and unauthorized activity. But are there other issues that still need to be addressed in the vulnerability disclosure policy area that aren't addressed by the framework or not sufficiently addressed?
Yeah, so all software will ship with vulnerabilities. We haven't been able to do it otherwise. It's unreasonable to also expect that an internal product security team is going to catch every vulnerability. So vulnerability discovery is going to be coming from external sources. And a lot of people have heard of bug bounties, but that is really a subset of the larger issue of vulnerability disclosure and vulnerability disclosure processes from external sources to government or external sources to other private parties. And this is coming up a lot in legislation in various forms. Like I can think of at least 4 legislative vehicles and agency guidances that this is coming up like right now. For example, the IoT Cybersecurity Improvement Act, NHTSA's Connected Vehicle Guidelines. So this is something where I think getting the policy right is really important. What Leonard was describing largely are authorized programs, so programs for authorized disclosure. And I really think that the Department of Justice and Leonard in particular have done a really amazing job at engaging with researchers and trying to find ways that they can legally operate, and do the thing that drives them. That type of model, though, where it's authorized and there is a liability protection or a bug bounty, that is appropriate for larger entities, particularly those that have the bandwidth and the expertise to review the perhaps large volume of disclosures that will come through a program like that, because you're essentially inviting the research. It's not necessarily appropriate for entities that don't have the bandwidth or don't have the expertise. But even for those entities, even for the ones that don't have as much bandwidth or expertise, we think that importantly, it is a basic cybersecurity practice to just have a mechanism for receiving vulnerability information from external sources, even if there's no reward involved, even if there's no bounty, even if there's no liability protection promised. And here we're just talking about having a point of contact and somebody on the other end of that point of contact. Right, so Rapid7, we are a cybersecurity company. We're very friendly with independent security researchers. We don't have a bug bounty, but we do have security@rapid7.com, where if you find a vulnerability in our products, you can disclose it to us, and we will review it and get back to you. Right, and that is the kind of basic process that we're talking about. This helps organizations and it helps researchers. For organizations, ultimately, if the point of the vulnerability disclosure is to get to a patch, it will help the organization become more secure if all goes well. It also tends to result in them being less surprised if the researcher uses that point of contact. For the researcher, it helps because having that point of contact, the communication is streamlined. And if the disclosure goes to the engineering team as opposed to the legal team, there tends to be less of a freak out. Right? It's more of an expression of goodwill, and ultimately, again, it can lead to a patch or at least greater transparency and communication with the company. So I wanted to make that distinction because I think it's a really important one. Bug bounties and authorized vulnerability disclosure programs are not appropriate for everybody, but we do think that at least having that point of contact, just having the process of being able to receive disclosures, should be a basic cybersecurity practice.
Thank you. Sam, I know you approach these issues from a practitioner standpoint. Can you talk a little bit about the disclosure policy as you see it, as the development of a disclosure policy as you see it from the practitioner standpoint, and issues about first identifying it and then how we approach patching and how we approach research around this too?
Sure. So the first thing I'd say, I'd like to build on what you said, Harley, which is I think there's degrees of maturity in terms of an organization's ability to be able to accept vulnerabilities from external sources. The most primitive ones, of course, say stay away, don't touch my code. Nobody wants to be that. And then the very first stage is, in fact, being able to say, yes, we can accept them and we have a process to look at them. I'd say before we dive into how vendors and how practitioners actually deal with vulnerabilities and updating them and patching software, we all want...
Can you turn your mic? Is your mic on?
Is my mic... I'm asking the question. Can you hear me? It's better. All right. It just need to be higher. We all want just hold it. We all want a community of professional testers that are producing good quality, responsible, vulnerabilities and giving them for the betterment of the quality of the software. So we want to get there, but that notion of maturity is much more fine-grained than just can I accept them, and at the other end of the spectrum, do I have a bug bounty program? There's a notion of technical debt as a developer and security debt as a security practitioner that has to be weaved in. The more rapid the vulnerabilities that you wind up patching for or adapting, the more unpredictable the system becomes, the harder the QA becomes. So if you start getting to a very high rate before you're mature, you will wind up producing more vulnerabilities, more instability, and frankly, you'll start to fail at probably your core business. And so this is why this notion of maturity is really important. There's a race from the moment there's a public disclosure about a vulnerability. And so far we've talked about very quickly when it's done by domestic testers who are subject to US law. It's also happening internationally. It's also happening in private labs. But from the moment these things become publicly known, it's a race to try to patch it before somebody exploits it. And so we want to try to have a reasonable period of time to make business decisions, impact R&D roadmaps or security, call them priorities or projects, be able to close those off and then be able to manage the impact of having to do these at speed. So quality becomes really important in your QA testing cycles. Your ability to produce new features gets impacted. Your ability to roll out new qualities of whatever your processes are. All those things get weighed together. So it's a huge subject.
And I'll pose this to the whole panel. Do you think there's sufficient guidance now on what are authorized activities? Is that issue sufficiently addressed?
Well, it's very rare now you find a company that says, don't touch my software. There's been a few of those. I would encourage folks any independent testers who are out there who want to do this, they should actually, before they even begin, rather than trying to develop these things in secret until they've got the killer disclosure, what they should do is choose the companies they want to work with, establish a rapport with them. Harley, you said it well, right? You have good relationships with many of these researchers. And make sure you don't run afoul of their legal departments, right? Find the way to do it. If it doesn't exist, work with them before you waste any time doing research. But I don't think we're at a point where it's really defensible to just say, leave my software alone. I'm not a lawyer, of course, but certainly as a practitioner, if anybody were to approach CyberReason or any of the companies I've worked for before, we would always have a very open door policy about that.
So I think that's less common than you might think.
Oh.
Right? Like having an open door policy or having just that basic ability to receive like a public facing point of
I
contact.
think it might be more common among security companies, less common among
Certainly.
non-security companies.
And
Yeah, absolutely.
I would imagine that a lot of,
That's
I've personally helped out with disclosures that for large companies that work in technology that don't necessarily have that point of contact. I mean, you have to go around fishing to not with a PH, but like to go look around for the proper point of contact to provide the disclosure to, and then it has to be shuttled elsewhere in the organization. And among smaller companies who themselves suffer from vulnerabilities just like everybody else, I think it's not very common.
No, smaller companies are a massive issue. This came up a little bit, although we didn't dive into it with the IoT subject, which is when you're an entrepreneurial company, maybe you have 30, 40 developers. Every agile sprint is cramming out the next feature. You don't know if you're going to be around in 2 years, and then someone calls up and says they've got something that gives root access to one of your devices. Mm-hmm. It's hard to know what to do with that. It could take you out of business, right? And if they've only been around for 12 months, they probably haven't thought about how to process it.
So are there other things that could be done to incentivize adoption of a policy for discovering and disclosing vulnerability?
So one of the recommendations that we've had is that this concept of vulnerability disclosure, the very basic type that I talked about, not necessarily authorized vulnerability disclosure, be baked into the NIST framework. I know that's being discussed. I don't know exactly where it is, but that is one thing that we thought of. But there are, as I mentioned earlier, there's several pieces of legislation and industry, or I should say agency guidance for industry that talk about vulnerability disclosure. And I think that it's important that those types of documents make this distinction, right? I mean, having a bug bounty like the type that is contemplated in the Hack DHS Act, that's very well and good, but we also want to see agencies at least have the point of contact. And it doesn't necessarily mean that the researcher providing the disclosure has a liability protection. That's a different beast. But having the point of contact should be a common practice.
Heather, so far the conversation is largely centered on issues around private-to-private sharing, private actors. But there are a number of pieces of legislation either introduced or moving through Congress intended to address the issue from a government perspective as well. Which of those do you find effective? Which do you think still need improvement?
So I think that the conversation so far has been very much around how to create a collaborative environment for bug bounties and vulnerability disclosures and kind of how we can all work together. Mozilla has been very focused on improving the collaborative relationship between government to companies. Because, inside this room, I think it's well appreciated that the government has, is one of the leading players in terms of this marketplace. Outside this room, I'm not sure that a lot of people realize exactly how core the government could be for this. There is an existing process by which the government kind of decides, do I want to take this vulnerability or this exploit, this tool, do I keep it and operationalize it? Do I disclose it? Do I, and that process in and of itself is not codified in law or an executive order or any of that. So there is an act that has been introduced bipartisan in the House and the Senate, the Patch Act, and someone asked me the other day what it stood for, and I have no idea. I've completely forgotten. But essentially codifying the existing vulnerabilities equities process and saying, look, you shouldn't overclassify the process by which you make these decisions and, creating kind of a level of trust, I hope, between the government and companies in terms of this relationship. It's funny because a lot of times when I talk to people in the military, the intelligence community, et cetera, if they're not directly working on this, they don't appreciate how much the companies want to work on this with them. And it can be a very collaborative exercise as opposed to adversarial. And certainly I think that when people are thinking about offensive operations or, how do I get the stuff I need? And here's the tool I can use. They think of it in a very adversarial way. We want to make sure that this is, in fact, can we port some of these industry best practices, some of this collaborative relationships with people who, yes, are trying to hack my stuff, and help the government kind of think about that. And there's a lot of really great folks thinking about that. Like this table has, a lot of them. With Ari and Michael. So I think that continuing that work makes sense. If we have a process inside the government that works, let's keep it.
Do you think that codifying it as opposed to, say, pursuing it through executive order or something like that is most effective or the best way to balance the desire to have a known and enforceable policy with the ability to be flexible as technology changes?
One of the things I really like about the Patch Act is it doesn't prescribe the process because the particulars of that process are going to evolve over time and the needs for that process are going to evolve over time. That said, I think that there's pros and cons to both codifying in law and in executive order. Either would make me quite happy. But putting that out there and saying, this is the process. Let's have some transparency and some oversight. Let's talk about the people who are in the room and what considerations they bring to the table and what, exactly what equity is there weighing when they go through and they say, I want this tool, I want to keep it, or, I really need it for this one thing. Or, hey, I think that this is going to impact government systems and consumers, and we really need to get this out to the people who can patch it. And I do think that takes advantage of some of this evolving vulnerability disclosure work, especially in some of the industries that have not traditionally been software industries who may not have that security point of contact. I think that the software and tech are way ahead, and then every time there's a breach in retail or connected car or IoT or other things, everyone scrambles to set this up. But there's, I think, a very good kind of understanding from some companies of how to do this, and that's where folks like Rapid7 can come in and hey, let us help you. So, but yeah, so there's, in terms of your question, codification or executive order, more clarity, more transparency, any of that would be wonderful. I think that, Mozilla went, to push for legislation because it's the most robust way to set this up. But that poses some hurdles.
So in a number of responses so far today, we've touched on or heard reference to spattering of adoption or adoption at different levels based on industry or knowledge. And I saw a recent data point that said 90% of Fortune 2000 companies still don't have a vulnerability disclosure program. Given the spread of threat surfaces as IoT comes around, given the importance of this, what do you think can be done to encourage adoption? We were just Leonard and I were just talking a little bit before the panel that this is no longer a very controversial issue. There's controversy around certain specifics, but the idea of having the policy and providing the guidelines, those kinds of things are no longer controversial. So what do you attribute, what are you seeing as reasons for the low adoption, and what do you think we can do to address that?
I tend to think that one of the challenges generally when you're dealing with voluntary efforts is what will be the driver, right? So we see this in information sharing as well. The notion of removing risks and costs may not be enough if there's not a sense that there's a benefit to it. And I think that case can be made over time where, when you hear former SecDef Ash Carter say that they ran their Hack the Pentagon program over 6 weeks and they discovered 123 new legitimate vulnerabilities at a cost of $150,000 compared to $1 million they would have otherwise spent. You start talking about where you see the benefits that may drive people, but we approach this issue with humility because we are not going to be the drivers of this, and so we're watching to see what will be the sense among private sector actors that this is something I really need to do. Will there just be enough success cases or what?
I'd put an idea out, which is nothing crystallizes a vendor's attention quite like the purchasing office, the legal counsel of the buyer, saying, "You don't do this, you don't get it." Right? A lot of people they choose which vendor to buy on the basis of best of breed or how well it works with other products, whatever the service area is. But if there's a risk mitigation, and I don't mean security risk, I mean risk for organizations, right? If the legal counsel is saying, just as they negotiate over warranty and liability, so how do you deal with this fact of life, that there will be vulnerabilities, they aren't going to come from you, show me your processes, and make sure that that meets a standard, as opposed to a regulation that says thou shalt, or hoping that people will say in the risk balance it's worth doing it. If you lose the $2 million deal because of it, it gets your attention, right? That's true for larger customers, those who service enterprises and even commercial. It gets harder, and I think we need some other solutions when you go down into the small, really small businesses and home users. But that gets the attention like very little else.
There's a couple of things that government can do and the private sector can do, and there are things that are happening already. For governments, there's already some of the bug bounty programs that have been proven successful and that are prompting this discussion about vulnerability disclosure with or without the bounty. There's guidances, like I mentioned earlier. NHTSA, the FDA's post-market cybersecurity guidance for medical devices includes vulnerability disclosure, without the protection element in it. I think those guidances are helpful, but they are sectoral. I think talking about it in forums like these is helpful, but I do wonder how effective that is, right? Like popularizing it in other fora for the private sector to take up on their own, because it doesn't require any legislation, doesn't require any regulation for companies to do this. But a lot of those resources are also already out there, right? Like the NTIA had a multi-stakeholder process devoted to this particular issue, both from the recipient's end as well as from the researcher's end. And I'm not sure that there's been a tremendous amount of uptake just based on the multi-stakeholder process. So, should government mandate this? I don't think so. But if we've heard several times today in previous panels, there has to be some sort of regulation is inevitable, something, and if that is true, then I think this is an issue that's worth talking about if we're going to have some sort of regulation about it. Even if it's just a company has to, be transparent about whether or not they have such a process, whether or not they do. If we're talking about cybersecurity regulation, then sure. But I think Congress is a ways away from that. So in the meantime, education efforts like what DOJ is doing and what we're doing right here.
If you contemplate approaching it from a regulatory perspective or some sort of mandate perspective, how do you structure that in such a way as to maintain flexibility for things such as size of company or risk to that particular company's operations? Can you still give flexibility in those areas and still achieve the goal?
Do you mean granting autonomy for people to decide?
Yes. Yeah. So that they would have some sort of sense of, I need to take this on as an issue that I need to know that I'm addressing, but yet not having the way that I address it be mandated to me.
I think in context, we should certainly not think of vulnerability disclosure as a substitute for a well-run internal cybersecurity program, right? And my understanding is that some companies use it for that. They use it to catch low-hanging fruit that they could address themselves if they were not effectively outsourcing the vulnerability discovery to external parties. For that, I think it's an inappropriate vehicle. So I think that it would have to be something that is wrapped up into something larger. There are several pieces, especially in the wake of Equifax, several pieces of broad cybersecurity legislation. We haven't endorsed any of them, to be clear. But for example, Senator Blumenthal introduced a bill, S-1900, I think it is. And it effectively punts to the Federal Trade Commission on administrative, physical, and technical safeguards. This would probably fall under an administrative safeguard, right? And so the Federal Trade Commission would then be responsible for coming up with the regulation. And I think that it would be appropriate in that discussion to build in flexibility for different size and level of expertise among businesses, among the regulated entity. And rulemaking is more flexible than legislation, so I don't think that's a bad approach.
Also, for what it's worth, I guess this is an issue that is not moving at the speed of government. It is, in just 2 years, at least from our vantage point, it's moved from a discussion at DOD to, at least for justice, 2 weeks ago at the Cambridge Cybersecurity Summit, you had the Deputy Attorney General exhorting companies to examine vulnerability disclosure programs to see if they'd be helpful as a means of, crowdsourcing discovery of vulnerabilities. I think this is an issue that is moving with some force and velocity, so much so that you have a panel of government, industry, and we're all in agreement. It's hard to find the controversy here. So that makes me think that this will become part of the fabric of what is assumed to be regular, routine, perhaps expected practice, you'd think.
Controversy makes panels fun. So maybe we'll try to do something. I'll try to do something a little different. If we look at development organizations, especially agile ones, they have a certain number of points they spend every sprint, right? So say you have 20 points to spend. And a terrible critical vulnerability comes out, and it will steal 10 of your points, right? So there goes half your functionality, you miss deadlines, things go horribly wrong, right? So you've got one of two approaches to try, and usually it's a mix of both. You'll say, I'll reserve some capacity every so many sprints to deal with these. And if my rates are too high, then I can either try, the second strategy is to squelch the source of them. So I will start to ignore the vulnerabilities, or I'll try to slow roll them or push back on them. Or I can try to build more capacity or do better quality. Those are big systemic things. So organizations who are trying to meet the next quarter's results, get the new feature out that will close more deals, vulnerabilities, they know they have to deal with them. They want to deal with them. But underlying it is the need to fix systemic issues throughout the organization. You're not doing your quality right. You don't have a good enough security office, product security office, as opposed to corporate security, who's testing and finding these things ahead of time. Those are hard to fix, and they take a long time. And what that means is, especially if you're a fast-growing or a smaller organization, you don't have time for it. So for all that everybody knows they're bad, and they know that they should do them, and they know they should embrace them, the reality is that in the risk equation of staying alive and producing new features versus burning these down faster or preventing them in the first place, their vulnerability disclosure is something they're either slow-rolling or ignoring. Don't know if that's controversial enough for you, but that's happening in organization after organization.
I have a sense, though, that that's something that we're seeing replicated across various cybersecurity concerns generally. That is, you have your large entities, your medium-sized, and your small, and by and large, at least at your smaller organizations, being able to keep pace with some of the things. So, I mean, and maybe that's part of the discussion about whether you make this a regulatory regime or not, and if it does, what it looks like, right? Because I think we're learning, are going to need to distinguish because the expectations will have to be different based on simple resources.
Yeah, that makes sense. So it's the incentives we're playing with, right? And that's where we start to get into what degree does government get involved in incentives, and to what degree do you preserve the autonomy for people to make those decisions. Personally, I think it comes back to risk, that organizations have to have a risk-based way to process this. And they should say there's a minimum level of how we want to handle vulnerability disclosure as an organization, and set that as a main goal. Because if you don't, then it will just be something that's one of the plates that you're always on the verge of dropping.
I think that speaks to what you were saying earlier. That when someone's trying to close that deal with a big enterprise customer, and they're like, "Yeah, well, we've got this trove of vulnerabilities we're just not thinking about." They're not going to get that deal. I think.
I think usually they're just trying to find a way of writing the policy good enough to satisfy them,
right?
And then say, "Well, then we'll implement it really quickly," which is a horrendous thing to do. I think that they are either in denial that they have very many and say they have good quality, or they're scrambling to figure out what the best practices are. Maybe they'll hire somebody quickly to do it. But is that person really empowered, and does it last? How much liability is that creating for an organization is a big problem.
That's the unfortunate truth. They're waiting for it to blow up in their face.
So that sets up a point of controversy pretty well. I don't think there's a good answer to it, which is at what point can a researcher go public if, before, without the vendor having authorized the researcher going public, right? So the researcher finds a vulnerability and they've disclosed it to the vendor and it's not patched yet. At what point can the researcher go public? And there's sort of like an industry best practice for this. For us, we contact the vendor first. We keep it confidential. We wait 15 days and contact US CERT. We wait an additional 45 days at minimum, before we go public. And we work with the vendor so that, if the vendor is working on a patch and whatnot, then we will extend it. So it usually goes well beyond 60 days. What if that process doesn't happen, though? What if the researcher discloses and the vendor sits on it, and the researcher finds evidence that this is being exploited against users in the wild, and the researcher is not able to get any information out of the vendor? They're ignoring, or they just can't reach them. What then? Can they go public? But on the flip side, it can also be gamed, right? We saw that in some disclosures in the past year, that they went public immediately and they used it to short the stock price of the company that was making the device. So there's a danger on both ends, depending on the amount of time. And I've seen some legislation that attempts to sort of mandate this, that the vendor must have time to make a patch before the researcher is able to go public. And I actually think that boundary is going to get pushed a lot if that were enshrined into law. It might be better to have a reasonable amount of time and have what's reasonable than be fought over in perpetuity. But I think where we come out on is that we would counsel against having a firm, giving it entirely into the hands of the vendor or the product manufacturer to make the disclosure.
Yeah, I think I agree. And giving companies that and researchers, kind of that contextual flexibility is really key. I've heard the same stories, and sometimes it takes 2 years to fix something like really core, and giving the company that time and they're really working on it, great. If it's super severe and the company's laughing it off, that's a different problem.
Yep. And then there's controversy over whether the company's really laughing it off, and what if there's disagreement on how severe the vulnerability is? The researcher thinks it's really severe, the company doesn't. The company's like, no, we're not gonna fix this. And that's where I think at the margins this becomes a gray area where the lawyers start to breathe heavy. But it's one, like I said, it doesn't necessarily have a good answer because it can be abused in both directions.
We've got a little bit of time for questions. Are there any questions from the audience? Yes. I think there's microphones available too. Okay.
Rapid7 probably. So my name's Matt Olney. I'm from Cisco Talos. I know Rapid7 will kind of understand some of the background of this question, but is there a need for protections for individual researchers to be put in place so that when they communicate in good faith as a good Samaritan to achieve a greater good of protecting everybody, that they are protected from corporations responding, even as so Cisco Talos engages in disclosures to companies as we do our own internal investigations, and even as a company with more lawyers than probably are in this building, we still have fights that I can't imagine an individual researcher having to go through. So what protections are in place, and what maybe should be in place for individual researchers that aren't sponsored by a giant, enormous corporation?
Couldn't have asked for a better question. Honestly, for something as dear to our hearts, the answer is a resounding yes. We think that there should be protections for researchers acting in good faith, and in fact, there are some. One example is the type of document, like the type of framework that the DOJ has produced, right? So authorized vulnerability disclosure. That is one way that a company can act to protect researchers. I think it has its limits. I think that having, as I said, just a point of contact ends up helping researchers in a very basic way. In terms of legal protections, we are supporters of CFA reform and DMCA reform to protect researchers. The DMCA often gets overlooked, right? So Section 1201 of the DMCA is actually a really big issue for researchers. And I've seen, cease and desist letters citing to the DMCA and not the CFAA more than once. Arguably, the liability there is more broad because it talks about individual devices that the individual can own, as opposed to CFA, which is more often about reaching into or affecting somebody else's computer. The good news on the DMCA is that there is a temporary legal protection for security researchers. It's not absolute. There are some caveats to it. There's a class of devices. It's pretty broad. It could be a bit broader. But by and large, under that temporary exemption, security researchers don't need the authorization of the copyright holder of the software to test software on a device that they own. But that's temporary. It has to be renewed, and there's a legislative push to make changes to DMCA. We'll see where that comes out on security researchers, but certainly we think that that temporary protection at least should be made permanent through legislation. CFA is a little bit trickier, because there we are talking largely about computers that other people own. One of the biggest difficulties is information that is publicly available, or and what's publicly available is often very fuzzy on the internet. And when it's publicly available, but there's a policy, like a written policy, as opposed to a technical barrier saying don't use the information for these purposes. And there, where we shake out is that the protection for researchers should not be absolute. As with DMCA, there are some limits to the protections that researchers should have, but there should be, at the very least, it should be harder to penalize researchers for violating CFA in good faith. So an example is the CFA it has both criminal penalties but also civil penalties. And researchers, in our experience, at least anecdotally, are facing more often civil threats as opposed to criminal threats from DOJ or from other prosecutors. And some of those civil threats are completely bogus, but they're very, very broad in terms of liability. If a researcher discloses a vulnerability to a company in good faith, and they have looked at their computer, they haven't penetrated it, for example, if the company spends $10,000 investigating the vulnerability, then that actually gives them a basis upon which they can sue the researcher. That we think is inappropriate. I mean, I talked with our product guys, and it's like at least $30,000 to perform that investigation, right? So it's actually quite easy, even if the researcher hasn't harmed the computer in any way. So there is wiggle room. I'm not sure that this is something that Congress is really willing to take up yet. In 5 years, there's been a big change in how policymakers perceive hackers. Like now, it's not just they're all evil people, operating in shadows. There's also an increasing recognition that there's security researchers and that there's white hat hackers. But providing legal protection in this environment, I'm not sure that they're ready to do that for CFA at least. DMCA maybe.
Are there any other questions? With that, please join me in thanking our panel.